to appeal in the matter of Iconix Luxembourg Holdings Sarl and Dream Pairs Europe Incorporated and another.
Yes.
Please, my lady, lords, I appear with Mr. St. Quinton for the appellant. My learned friend, Mr. Van Heegen, and Mr. Barclay appear for the respondents. With your permission, I propose to take the following course, which is to deal with straight with the issue of post-sale confusion, explain to the extent necessary what it is and how it arises in a case like this, and how it did arise, and how it was treated by the judge. Then to look at the authorities. There is a little bit of controversy at the edges of the doctrine of post-sale confusion. I'll hopefully focus on those. And then really deal with the other grounds a bit more briefly, taking very much on board the points that were made in the grant of permission. We do say that some of those grounds have significance as part of the post-sale confusion issue, but also have some independent significance.
Sorry, just a moment, please. My pens don't seem to have made it to court. Could you just ask? Sorry, could you just go and find Sean? Sorry. Oh yes, I'll just ask her to pop into comment. Sorry, it's just if I run out of ink, then I have nothing to write with.
So, if I could start then just dealing with the issue of post-sale confusion.
Yes.
What it is. If one looks at the Act itself, Section 10.2 is the relevant provision in this case, and you will find that in the bundle at tabs 38. Sorry, that's the Joint Authorities bundle 5. On tab 38. 39, I apologise.
Thank you.
Page 1367. And there are really only two provisions that I was proposing to take the court to. The first of them relates to how a trademark is infringed. A person infringes a registered trademark using in the course of trade a sign which is identical with the trademark in relation to goods, I think it would say goods or services, which are identical with those for which is registered, or a person infringes a registered trademark if he uses in the course of trade a sign where either the sign is identical, leave that aside, or the sign is similar to the trademark and is used in relation to goods or services, identical with or similar, and there exists a likelihood of confusion on the part of the public, which includes the likelihood of association. And the other provision is Section 10.4, if you look at the middle of that section. For the purposes of this section, a person uses a sign if in particular he affixes it to goods or the packaging, offers or exposes goods for sale, puts them on the market, stocks them under the sign, imports, exports, and there are some other examples, using as a company name, using in business papers and so on. And really the only purpose of taking thought to that is to emphasise the fact that post-sale confusion is not dealing with a different sign. It is dealing with the sign that has been affixed, for example, in a case such as this. And what happens to that sign, what context that sign is viewed in. Post-sale confusion is, in essence, confusion on the part of an average consumer, or significant proportion of average consumers, in a context other than the point of sale. Now, the Act is obviously silent on that. It has come in via the assessment of context in a number of cases, and I propose to look at those cases briefly a bit later. We say the law is quite clear. Whilst there may have been some initial controversy, the position is now settled, at least in the UK, that this is in principle actionable. And in the present case, on the facts, the position arises by contrasting the Amazon context, the point of sale, and what happens to the shoes as worn by consumers out in the wild, as it were. Now, just to start with the types of goods that we are dealing with, we can find reference to that in the judgment at paragraph 90. You take the core bundle. I can put away the authorities bundles in a moment and focus on the judgment and some of the authorities in the supplemental bundle. So, paragraph 90 deals with the types of goods that were sold. There's a little bit of an issue about the numbers, but the types of goods were set out there. Between December 2018 and December 22, there'd been net sales of shoes, including 2,844 children's trainers, 4,802 of the relevant adult football boots, 2,262 of the relevant children's football boots, and 1,453 of the relevant children's hiking sandals. Now, the following paragraph, as explained in the re-amended particulars of claim, the claimant specifically complains about the use of the DP, that's the Dream Pairs logo, or sign as it's sometimes called in the decision, on certain specific products. And then there's an annex to the judgment showing images of those, but the claim is not limited to those. And if you wanted to just remind yourselves of the pictures that are annexed to the judgment, you'll see them at 92. And there's some examples there. Now, all of those images come from the Amazon sales channel. There are pictures of those in the particulars of claim, which is at tab 7, and one can see examples of those, and these were the images that were for the judge. Tab 7, page 135. And you can see that, for example, the image at the top of page 135, in the usual way on Amazon, one has the clickable little images, and you can blow those up. And indeed, if the court requires, we have larger prints of those, but I hope not to be able to not to need to look at those. But these are all of the products. If you look over the page, you can see there's the kids' trainers, and then the kids' sandals on 137, and then some more trainers on 138, and so on. Some football boots on 141 and 142. So that's those are the type of goods. The judge did consider an important point in the case, which is that perspective. Now, if you turn please to 137 of the judgment, the judge records, that's on page 83, the judge records a submission made by claimant at trial. The claimant also argued that the sign was not always presented, whether in the Amazon images or in actual use, straight on to the viewer. In some of the images, because of the angle from which it was shot, the sign could appear rather more elongated. The claimants also submitted that a viewer of the sign would not always be able to see the break in the outer shape or the P-like form in the middle. The claimant contended that there was a high degree of similarity between the marks and sign. And the judge says he cannot accept that submission. It appears to me that even looking at the images most relied upon by the claimant, the sign presents as a tilted, broken, slightly rounded off square with a P-like form in the middle. It hardly resembles, even in the angled photos, a pair of sideways sitting stretched out diamonds. And this is true even of the photos where the image is not square on and there's an element of perspective. Now, the judge then concludes that section by saying, the claimant rested a good deal of its case on these angled images and the effect of perspective, but the set of images for each product includes in each case a square-on photo. I have summarized the presentation of the Amazon pages above. I find that an average consumer would review each of the images and would see the footwear from various angles, including square-on. I also repeat for emphasis the point made in the previous paragraph, that even without these further images, and even in the more angled photos, where perspective plays some part, there's only the faintest resemblance between the sign and the marks. Now, the essential problem with that analysis, and I'll show you other passages when he deals with the issue of purports to deal with the issue of post-sale confusion, is that the judge is faced with a series of images on Amazon, all of which were eye level. Some were square on, many, even most, were at a slight sideways angle. But the judge knew and recorded the point, his judgment, that this was a square with a P and a broken line. So what the judge was saying was, my brain is not fooled even when you turn it laterally. And that's absolutely to be expected. That's normal visual perception with the brain seeing a square, and when it's turned on side, processing it as a square slightly at an angle, but never losing the basic point that that brain has already been conditioned to see the square. Now, that's the position on the Amazon page, because all of the sets of images include a square-on, eye-level view. But it's important to distinguish between that and the post-sale context, because at the post-sale context, the simple position is that when these shoes are viewed from a normal vantage point, for example, the height of a person, average height, looking down at even close by, to some extent looking close by is worse, because the image is flattened if the logo is on the side of the shoe. A square becomes flattened and elongated. This is just basic perspective. And that is from anywhere that you are viewing the square. You're viewing it anywhere on the 360-degree radius. Well, some angles you won't be able to see it at all, perhaps directly behind and directly in front. But anywhere else, from a normal height, that square is going to be flattened. And when that person is unaware that it's a square, never heard of a square, never encountered the DP, the Dream Pairs shoe or logo in any way, shape or form, then there is no reason for them to consider that they are looking at a flattened square, as the judge did. The judge, rightly and understandably, having been conditioned to look at this as a square, was not fooled by the optical illusion, if you will, of perspective, whereas anyone viewing from a normal height and a normal way in the post-sale environment would. Now, we say there's a couple of other reasons why they would. The first of them is that the Umbro mark, if I could record the judge's submission on that, the judge held that the marks, and I quote from paragraph 83, he records that the Umbro mark was, I'm just going to read it out and I'll give you a paragraph number in a moment. The marks have an extremely high level of distinctive character. both inherently, because the marks have no inherent meaning to goods, and there's no evidence of any other mark for footwear that looks anything like the marks, and because of the hugely extensive use that's been made of them. That leads to a greater likelihood of confusion. Now, we would say, we would add to that, that leads to a greater likelihood that a consumer seeing these signs from a normal vantage point, no, we're not relying on muddiness, we're not relying on excessive distance. We say that just seeing the marks in a normal way, they are more likely to be seen as the Umbro marks because of fame and repute.
Yeah. So what you were just quoting from was paragraph 1.5.
I'm very grateful, my lord. Yes. I mean, before that section, the judge talks about the use scale of the use of the Umbro marks. These are signs that have appeared on the boots of Michael Owen and Alan Shearer. The England football team, national football team, played in Umbro up until 2012. They continue to sponsor many other teams, and before that, I think there's evidence that in the '66 World Cup, most of the teams were wearing Umbro. So certainly older people are aware, but we would say pretty much anyone over the age of about 20 would be aware, most people, because, or anyone that has an interest in sport, because they were the sponsors of the England football team. And that makes it more likely that when they are shown something like that, they are very likely, we say, to see it in the way that we suggest. Now, the judge did deal with what was said to be post-sale confusion, or the post-sale context, but we say dealt with it unsatisfactorily because never considered the point of a viewer in a normal environment, viewing environment, seeing shoes worn on another person would not be conditioned by any square version of the Dream Pairs logo. And if I take you to that part. It's 141 and 142. Actually, I took you to 139 earlier, so I'll just bridge the two bits. I agree with the claim at 140. I agree with the claim that it's possible that for some presentations of the DP logo, the consumer would not notice a break in the outer figure. I'm unable to agree with the claimant, however, that the average consumer would not notice the P-like form in the middle of the DP logo. It's the distinctive and dominant element. Then he goes on to say, as to someone seeing the footwear itself being worn post-sale, and he posits three scenarios: in the street, on the football pitch, or in the changing room, it appears to me that the sign would again present as explained above, as a tilted, round-cornered, broken square with P form in the middle. It would not appear to a third party as a pair of elongated sideways sitting diamonds. I don't think there's absolutely no similarity. They're both involve rhomboid shapes with an outer and inner dominant element. But there are multiple variants, a very low degree of similarity. The problem with that is that the judge never considers someone looking at the top-down view. And I just wanted to show, see, there are many ways that my lord and lady may consider this point, but I know that my learned friends propose to show you some shoes. I think we have one pair each of the same shoes. So at some point you might want to look at those. But our basic point is that as soon as you go anywhere from an elevated view, looking down, it's much worse if someone's wearing them down there. That square is not a square. It's just simply not a square. And although the judge considered angles, he did not consider angles in circumstances where there was no education, as it's sometimes put in trademarks, that this is a square. to show you some examples of the sort of thing from the bundle we have in mind, if you take the appeal skeleton and look at page 29, these images, that is still quite close to eye level, the top image, but you can see already it's beginning to flatten, and then the one below that, again, it's quite close, but of course this is normal perspective. There's nothing, you would say, or shouldn't be anything controversial about that. And then I mentioned before the particulars of claim, and the annexes there too. That's behind tab 7. I wanted to show you at page 136. You can see again these images are actually it's almost the same image, but it's not exactly the same. Yes, it's sorry, 145. There's 4 shoes, not 3. And I hope you can see, we've got larger copies if necessary, but you can see just from the top, so the second image down from the top, the blue shoe and the purple shoe. This is really just to show, I'm not relying so much on loss of detail here. Of course, detail gets lost from any sort of distance. What I rely upon is the flattening of perspective in particular. And what happens naturally there is the eye can't process all the detail. And as a result of that, what happens is you see an Umbro logo, slightly smaller, or something very similar there too. We say a average consumer or substantial proportion of them seeing the mark in this sign in this environment will see it in those terms. This is not, we say, surprising in light of the fame and repute of the trademarks. Now, there are some, I might say, ancillary points that make this, in a sense, a natural result. The defendants have chosen to use their logo very small. They have chosen to use a square that they must know will be flattened in when viewed from above. They put it on very different types of textured materials and on a curved surface. I should say not all of the uses are like this. You'll be shown, no doubt, a small version. It's on a button, you can barely see it. And some are higher on the cuff, some have green pairs, some don't. But these are the risks that come with choosing a trademark. When you choose a trademark, you have to consider not only the perfect, crisp, black and white representation that exists on the register, but you have to consider that mark in use. And there's nothing, we say, surprising in that. The judge found in this case that there was nothing similar to either of these two marks. So to some extent, the author, the defendant is to some extent an author of its own misfortune. Now, for example, the defendant could have done its square flat, horizontally, standing normally. DP is what he intended to communicate by the sign. have a picture of it here, but that's the sort of, it could have been like that instead of like that. And that is coming into a market where the defendant should know, or taken to be.
But it doesn't matter because it's not about subjective intent. Certainly, in the context of likelihood of confusion, and that may be relevant on the 10.3 claim, but so far as likelihood of confusion is concerned, even if their intent was to avoid confusion, if objectively it's confusing in this, that's enough.
Quite, we certainly agree with that. But there is a suggestion that somehow post-sale confusion is sort of unfair because it comes in and distorts the mark, or one sees this in the sort of drinks cases about names in noisy pubs and smoky bars where you can't see the name properly, or one sees this in twisted bottles that might be sold in a supermarket. To some extent, the trademark just has to live in the real world, and if it's causing a problem in the real world, then that's to some extent tough. Now, I just wanted to mention a couple of other sort of ancillary concepts, which are, first of all, who is the consumer? Now, the judge held in this case that the average consumer is the UK adult population. So we didn't have a restricted consumer, and we conceded that there was no, I think initially we thought about arguing whether there was a lower level of attentiveness in the post-sale environment than at the transactional stage. But in the end, we conceded, and the judge records this, that it's common ground that the consumer is moderately attentive, or it was the same level of attentiveness. So the shoes are fairly cheap on Amazon. People buy things rather quickly on Amazon. And by the same token, in the real world, people may make a judgment as to what they're looking at quite quickly as well. We're not contending for, there's a suggestion that from the defendants, principally I think in reliance on an article by one of the academics that is in the bundles, that somehow the post-sale consumer has to be in consumer mode, has to be someone that, it depends what one means by consumer mode, but it might go so far as to suggest, and it is suggested by the academics, by Ganji, that they have to be sort of ready to transact, or it has to cause a transaction or somehow influence a transaction. We say that's not the law, and that can't be right. And it would be impossible to ascertain, because sometimes they might be triggered to buy, sometimes they may not be triggered to buy, they may be deterred from buying. The key concept is who is the average consumer, and that is the adult UK population exercising a moderate degree of attentiveness. And nor do we suggest that people in the post-sale world are sort of dumb visual receptors, just sort of responding to the shapes and perspective of things. This is a consumer who's being presented with an elongated diamond and has no reason to think that it's anything other than something they may have seen before, or they may link it to something they've seen before. They may see it in a locker room, players at feet. They may see it in the street, and so on. This, we do accept the defendant's argument that in the post-sale environment, some people, it's difficult to ascertain, it might even be the majority, are simply disengaged casual observers, even if they are consumers. So it might be that you see someone walking down the street with these trainers, these adult trainers, and it's simply not noticed. It doesn't register. That's fine. That's consistent with the claimant's case, the appellant's case, because for the reasons given by the Court of Appeal recently in the Samsung Swatch case, that you don't have to confuse all the people all the time. It's a significant proportion of people. It must warrant the court's intervention. And if if the court has a view that there is enough of a problem, then that's likely to be enough, generally, to put it in a very circular way. But what we do not accept is that somehow the post-sale scenario that I'm positing is in any way fanciful or speculative. This is the entirely normal view, looking at someone wearing shoes. If you think about it, when you buy shoes, even when they have those shoe mirrors in the shops, that's to get you down to eye level so that you can have a good look at them. In fact, shoes in use, worn, do look very different. And certainly when they're advertised on Amazon or anywhere else, they're almost always pictured very close from the side so that you can see the elegance of the design or whatever it is. As I said before, we don't rely particularly on muddiness, but that might be said to be a background factor. The reason that was so significant was I think there was a picture of the Dream Pairs logo covered in mud, and that was the subject of a bit of a debate, a trial. We rely on ordinary lighting, ordinary conditions, which vary. We rely on ordinary weather, ordinary distance, which would be quite close, medium distance. We certainly don't rely on great distance, because then it just looks like a dot, probably. Now, I also need to deal with the different kinds of shoes. Obviously, for these kind of shoes, the boot shoes, that use is on the side, as it is for the, I think these are snow boots or something. With or without Dream Pairs, we say that makes no difference, because once they have seen the Umbro logo or something similar, then the words Dream Pairs are not going to make much difference, not least for the same reason that the judge dismissed the instance of confusion that we had. It was a US instance, which was described as Umbro Dream Pair, and the judge regarded that as being quite descriptive. We say the same thing when it comes to that snow boot or any other uses. Now there are some other footwear that's perhaps this one, for example. I'm looking at a red and black trainer. This has the logo on the top. Now when that's looked at from the side, it gets distorted in a different direction, but still we say that's not likely to make much difference. Other companies might wish to complain about that. And then there are then there's perhaps at the margins, there's use on the, I think it's called the outer sole, the sole of the shoe, lady's shoe. We do complain in relation to shoes of any kind, because we've got a registration for footwear and clothing that contain a visible use of the mark. And if it's not on the shoe, I think actually a large amount of sales were made into the UK without the logo on it, on them. So in relation to those, the ladies' shoes principally, we obviously don't make any complaint about those. Now, it would be said against us that the judge did consider post-sale in the passages that I took you to. He considered that environment, but we say it was missing a fundamental piece of the puzzle. He was assimilating the Amazon use and the images that were shown on the Amazon pages with the post-sale environment. And this isn't a question of weight or a challenge to the assessment, because it simply was not considered at all. And it's in this context that we have other issues in the case that start to, we say, look a little bit shaky as well, because when the judge is expressing the view that there's only a very faint resemblance, very low similarity, one has to consider specifically what the judge is comparing with what and in what context. I'll come to that a little bit later on. We also say that ground is a reason to dismiss the EUIPO decisions in this case, but also some of the others relied upon by my learned friend in the bundle, such as Chanel, because the approach of the EUIPO is to consider the marks in the form as shown on the register, oriented in that way. So when you have a look at, I can just quickly jump forward to the, actually I won't do that, I was going to deal with authorities in a moment. But when you have a case like the Chanel case, where you have quite similar interlocking Cs, but one is orientated vertically, one horizontally, they look different in that orientation. And the office and the General Court is very clear that it is not the task of the EUIPO in a registrability decision to consider post-sale, or consider use specifically is what they say, way that it could be used in different orientations. They look at it as it is on the register. And there's pretty good reason for that, because otherwise they would be trying an infringement case before they knew it. But we say, in this case, I'll show you the authorities in due course, we say that the infringement position is very, very different. You must look at the specific forms of use and what has happened, what is likely to have happened in that particular context. And to some extent, that deals with that there are some, might put on their face, unhelpful EUIPO decisions against us on these marks, but there's also other EUIPO decisions relied upon by my learned friend. So I think at this point it might be useful if I look at some of the authorities. I hope that my lords had a chance to read the sideline sections in the authorities bundle. What I was going to do is just to give a brief comment on one or two of the cases, or actually on more than one or two, on a number of the cases, but I'll try and keep it as brief as possible. So the starting point in the analysis of post-sale confusion is usually taken to be the judgment of the Court of Justice, but in particular the Court of Appeal on the return leg from the Court of Justice in the Arsenal Football Club, Arsenal and Reed case. And this was a case about football scarves and various other items which bore the name Arsenal on them. And there was a major issue in the case about whether that was trademark use or whether it was use as a badge of allegiance and therefore either not trademark use or not distinctive. That particular issue was settled by the Court of Justice on the basis that what mattered was whether it damaged the functions of the mark, and in particular the origin function of the mark. But the case was a 10.1 case. I read you the provision on section 10.1, and the purpose of that is really to distinguish between cases where the defendant uses an identical mark, sign to the mark. And in those cases, there's effectively a presumption of confusion. So these cases are really about whether it is used as a mark at all, because if it is used as a mark, it infringes. You don't have to directly prove likelihood of confusion as a sort of shorthand version of a very complicated issue of law that has been the subject of many, many cases. But the key point here is that on page 17...
You need to give us the reference first.
Which one? Oh, sorry, I'm looking at the Court of Appeal. And it's, sorry, yes, it's...
to know which of the 5 bundles you're in and which tab.
I'm sorry, I thought I'd announced that. So it is tab 1, bundle 1.
Right.
And as I say, this was the return leg. And if you turn to page 17, this is Lord Justice Aldous dealing with the ECJ case, which I'll come to when I get to that, to those cases specifically. If I need to, because a lot of them are summarised and commented upon in the judgments, in our domestic judgments. So 43, and about 4 lines down there, the court states that there's a clear possibility in the present case that consumers may interpret the sign as designating Arsenal as the undertaking of origin in a case where the goods are taken away from Mr. Reed and therefore not subject to Mr. Reed's explanation that they do not come from Arsenal. Now, the facts were that there was a big size, my client, Mr. Reed, I was junior counsel in the case originally, he had a big notice on his stand saying nothing to do with Arsenal. This is independent. And I think he might have even said badge of allegiance at some point. And basically, that was a problem because if you take a scarf and you give it to someone as a gift, for example, they don't see the disclaimer. And although the Court of Justice did not say very much about it, they did at least acknowledge that in the post-sale environment, there was a possibility that people would take Arsenal as an indication of origin. And if that was the case, then because it was a 10-1 case, there was, in principle, infringement. Now, we say there's nothing in the distinction between 10-1 and 10-2. We say that although a lot of the cases were on 10-1, that's because they were not concerned with showing confusion. They still had to show damage to the essential function in relation to the average consumer. So in these circumstances, that would be applied to our case, an adult, member of the adult population, and taking it as a trademark. And then if it's identical to the trademark, then there would be essentially a presumption of confusion. The reason I say that is because in the Dev Ganji article, which we'll look at in a moment, there is some reliance placed upon that point about it being a 10-1 case. Now, there is obviously a distinction between 10-1 and 10-2, but we say, so far as acknowledging that the post-sale context is relevant, that's a distinction without a difference. The next case, and this is the Julius Salmon and Tetrasil case, a judgment of Mr. Justice Kitchen as he then was. That's the next tab, and you can see, and this may be shortcut to actually looking at the ECJ decisions. This is as the doctrine starts to take root. I mean, it's not, you don't get very much at the beginning, it's fair to say. Paragraph 49, the judge cites the Anheuser-Busch and Budvar case, which again is saying that it's a double identity case. You see at the bottom of the page, it's reserved to cases in which the third party's use affects or is liable to affect the functions, and it cites Arsenal. And then 60, that's the case where the use of the sign is a material link. It must be established where the consumer is targeted, including those who are confronted with the goods after they have left the third party's point of sale, are likely to interpret the sign as it is used as designating or tending to designate the undertaking from which the goods originate. And I think that's pretty much all we get from that case. This was essentially cited by the judge in that case in order to acknowledge that that context was a legitimate one. Now, I think that's probably all I wanted to say about that. You haven't yet been shown Arsenal and Reed Court of Justice, but I think I've got a case that will deal with that, and it's the rather chunky one, the next tab, 3, data card and Umbro, which is generally regarded as the sort of the first principled discussion of the issue, and also acknowledgement of the controversy that may surround it. But what we had there was a judgment of Mr. Justice Arnold, as he then was, dealing with with a patent as well as trademark, and it was in relation to ribbons compatible with computer products, printed ink, and there was quite a lot of the judgment obviously relates to that issue, the patent issue, but if we pick it up at 148, and in particular the highlighted bit, I think it's highlighted by my learned friends, 275. This is the point I was trying to make earlier about the difference between the EFBO and a infringement case. The judge says there's an important difference between the comparison of marks in the registration context and the comparison of mark inside an infringement context, namely that the former requires consideration of notional and fair use, while the latter requires consideration of the use that has actually been made of the sign in context. And that distinction is made in the O2 case. And the judge referred to a previous judgment of his in Oxif, where he dealt with, in particular, what was called initial interest confusion, or confusion prior to the transaction. Now, he then starts with 277 with the discussion of post-sale confusion. Now, I suspect that probably the easiest thing would be for me to remind you or ask you to look at those paragraphs. I'll read them all out.
Dave, would you like us to read?
So
There's some rather extensive quotations from the Courts of Justice.
I mean, I wonder if it might then in that case be more useful for me to just highlight some sections. So 279, the judge refers to some academic commentary at 277, and then refers to the fact that he expressly refrained from commenting on that in Oxif. It didn't arise. It does arise in the present case. The advocates before the judge were particularly helpful, seemed. Counsel for data card submitted that post-sale confusion was capable of demonstrating confusion. Those counsel for legal submitted that it was not. The question of post-sale confusion has been touched on by the Court of Justice, the 3 judgments, and then there's a discussion of the Court of Justice judgment, and I think that's what I meant by being able to rely on this. And again, a lot of these paragraphs relate to the 10-1 basis of infringement, which I say put to one side.
Yeah, but the point you picked up by reference to the Court of Appeal's subsequent decision is what's in the last sentence of paragraph 57 of the quote.
Yes. There's a clear possibility in the present case that some consumers, in particular if they've come across the goods after they've been sold by Mr. Reed and taken away from a stall, may interpret the sign as designating Arsenal FC as the undertaking of the origin. Now, in a likelihood of confusion case, you could replace those words with may interpret the sign as, contrary to fact, indicating Arsenal Football Club because of its similarity to the sign, to the marks, and therefore because they are confused. So we say there's no real distinction there. Now
that's the point that's discussed in paragraph 280.
I'm sorry, not.
That's the point that's discussed in paragraph 280.
Yes. Yes. The sign function, nevertheless, 57 appears to acknowledge the relevance of post-sale confusion when considering the impact of the use of the sign, which of course is not the same as that as requiring a likelihood of confusion. Now, it then summarises the Budweiser case.
Oh, I wish. It actually quotes it at length. But then you get the conclusion that's drawn from it at 282.
Yes. And then we would say the same, essentially the same as Arsenal. Again, 60 appears to acknowledge the relevance of post-sale confusion. And then we come to the Ruiz-Picasso case, which is a strange sort of case. And I need to sort of state what we say about it. The starting point is that was a registrability case involving the names of cars. And the Court of Justice was faced with a bit of a dilemma because if you took the vantage point of consumers, someone walking down the street and a car whizzes by and they see in a blur a name, that might lead to an over-expansive view of a likelihood of confusion. and in particular in relation to goods such as cars, which are high-priced goods, the second most expensive thing people will ever buy, then it seems a bit artificial to take the vantage point of that person. We say in relation to this, the starting point is this was a case about the level of attention to be paid in a registrability
And
case.
that's what I said at 284 to 285.
I was looking at what you said about Mr. Carr's, I think it was Mr. Carr's submission, as he then was, which he said it was about the level of attentiveness. And we say the reason for that is because the EUIPO and the General Court and the Court of Justice are dealing with things differently. They've got to come up with an average consumer. They don't have examples of use. They look at the goods, they look at the marks, and they've got to take a reasonable view. And we say that this case, although on one view, my learned friend no doubt will address you on it, it might be said that it draws a distinction between the inherent level of attentiveness of consumers at the point of sale and the post-sale environment. We say that takes them nowhere because effectively we've conceded that the position is the same. We're not trying to rely on a lower level of attention at the in the post-sale world. And also it should be noted, these goods are very different from clothing, which are relative, and footwear, which are relatively low priced. It's interesting to see the number of clothing cases, I'll show you another one shortly, that sort of deal with post-sale confusion, because clothing and footwear are relatively inexpensive items, bought visually, bought by eye, and the mark tends to adorn the goods in a rather prominent position afterwards in the post-sale world. And so we say unsurprising that the post-sale confusion is considered in this context. Now, just to go on with this case, I think we could probably conclude having 284 is the passage that Lord Justice Arnold referred to, and he accepts the analysis that the entire passage is really about the level of attention which is deemed to be displayed by the average consumer. On balance, so it's a rather cautious conclusion. It seems to me that the case law of the Court of Justice supports the proposition that post-sale confusion can be relied upon in support of a claim under Article 5.1b, and there's citation of a Dutch case, which I don't think is before you. Now, then what's interesting is the next passage, 288, which I'd ask you just to read yourself, which is sort of a justification for post-sale confusion, that gives novel, unique reasons, not just taken from the previous case. So that's where we come out at the, and obviously this case received quite a bit of attention at the time. It's being sort of a case that had sort of formulated post-sale confusion in a more detailed way than had hitherto been done by either the Court of Justice or the Court of Appeal in Arsenal. I wanted to show you Specsavers, really just very briefly, to rely upon what is now and still regarded as the test on context, because context is very important in trademarks, and it doesn't just come up in post-sale confusion, it comes up in every way. The Amazon context is a perfectly legitimate context as well. And if I can take you to page 199. So that follows long citation and discussion of the O2 case and how far context goes. My learned friend has sidelined that, so perhaps you can disagree with that. We say, we rely on paragraphs 85 to,
Well, I don't think we need to worry about that because that's just quoting what he's disagreeing with.
well,
The conclusion is at 87.
well, we do make just a small point on this, which is he disagrees with the notion that somehow context is limited. I think you said that it might be limited because the word was used in the judgments. But 86, he says it's not entirely clear to me what Arnold and the parties had in mind by the phrase circumstances prior to, simultaneous with, and subsequent to the use of the sign. But it must, I think, be seen in the light of the particular and rather specific issue in that case, which is whether Article 9.1 be extended to confusion arising from use of the sign in advertising and promotional materials, so-called initial interest confusion, whether or not any sale resulted and whether or not the consumer remained confused at the time of any such sale. The judge held that initial interest confusion was actionable. At least in the circumstances of that case, it mattered not that it was dispelled at a later time. Now, what's significant there is the judge doesn't disagree with the application of that doctrine in that case. What he does is he generalises that, Lord Justice Kitchen as he then was, in the next paragraph. In my judgment, the general position is now clear. In assessing the likelihood of confusion arising from the use of a sign, the court must consider the matter from the perspective of the average consumer of the goods or services and must take into account all the circumstances of that use that are likely to operate in that consumer's mind in considering the sign and the impression it is likely to make on him. The sign is not to be considered stripped of its context. Now that, we submit, is a very broad test, and it is one that is stated right after there's a discussion of initial interest confusion. We note in particular that it is all the circumstances of that use that are likely to operate in that average consumer's mind in considering the sign. So it's when presented with the sign and the impression it's likely to make on him. This is the case that's been discussed, and that test is still cited. I say still because in trademarks, 12 years is a long time, but that test is obviously cited in every infringement case, cited in this case. We say that is very broad, and the sequencing of the reasoning there is also significant. So the next case is the Jack Wills case, and there was I'll skip over the one, so I'll skip over tab 6. And just take you through the Jack Wills case, which was about the use of an anthropomorphic bird logo on the front of clothing, so another clothing case. And to be fair, in this case, there was not a great deal of discussion, post-sale confusion, but it was one of the factors. If you look at page 308, this follows a passage where there's discussion of points in the defendant's favour, reasons why people are not confused. The clothing being in a particular department with the linear trademark and so on and so forth. And the judge says, I accept that these are all relevant factors to take into account, but they're not determinative cumulatively. I accept that consumers will have become accustomed to distinguishing between different bird logos, but they're not accustomed to distinguishing between logos consisting of silhouettes of anthropomorphic birds wearing top hats. Again, linear is discussed, and then there's discussion of the potential for initial interest confusion, and then people who saw a friend, relative, or acquaintance wearing a shirt or sweater with the pigeon logo would not see a linear label or swing ticket. Thus, there's the potential for post-sale confusion. The fact that House of Fraser does not sell that style of clothing would not prevent consumers from believing there might be, and so on. And really is it for the case, but it is one of the factors there that is, or one of the contexts in which the judge is concerned to take into account, and indeed overall holds there to be a likelihood of confusion. But it's fair to say that case wasn't determinative, it was simply one of the relevant contexts, as it often is, as it would be here. Now, the Interflora and Marks and Spencer's case, both sides relying, that's the next bundle, and it's tab 8, Court of Appeal. I think the purpose of this being put in by my learned friends is to discuss the controversy over initial interest confusion. And so if I can pick it up, 377. This was a case about keyword advertising, and that's an important point to bear in mind right at the outset. The court was dealing with novel facts, a novel form of infringement. There were questions about whether there was even use of the mark because it was, in a sense, invisible. Consumers would type in the word Interflora flowers, and they'd be presented with Marks and Spencer's advertising. And so it was argued there was no use of Interflora by defendants. All of those issues were very interesting. One issue for the purposes of today is the discussion of initial interest confusion. And the judge, Justice Arnold, had held that, relying on the Oxif case at 152 of this judgment, that there was initial interest confusion. Now, the Court of Appeal disagreed with that, but not in a manner that we say jeopardizes either initial interest confusion generally and much less post-sale confusion, for the following reason, that Lord Justice Kitchen in the Court of Appeal had difficulty with the application of initial interest confusion in a keyword advertising case. We say that's very clear from the discussion where at 155. And the reason for that was because the Court of Justice in Google France had formulated an entirely new test purely for the purposes of keyword advertising. Well, there's an argument about how far it goes, but at this stage, it was considered to be a novel test, and the test was whether the average internet user can tell with difficulty that the website or the entry or the advertisement emanates from the trademark proprietor. A sort of difficulty in telling test, the vagueness test, which had not hitherto been formulated by the Court of Justice. And Lord Justice Kitchen is there saying it's not helpful to seek to import the doctrine of initial interest confusion, at least so far as it applies to the use of a sign the same or similar to a trademark as a keyword in an internet referencing service. And it has the potential positively to mislead. We say that for the following reasons. First of those is the Court of Justice has already enunciated in clear and unambiguous terms the test that must be applied. And then it's this discussion of the other cases. 156, these tests have been formulated by the court with great care and reflect the importance of trademarks in developing a system of sort of competition, and so on. The court has acknowledged that internet advertising on the basis of keywords corresponding to trademarks is not inherently objectionable, and so on. And this is about keywords, about the importance of internet information and websites, and so on, being subject to a sui generis test, we would say, although there has been application of that keyword test in other environments. And the reason I say that is because in Specsavers, when formulating the context test, the same judge, Lord Justice Kitchen, didn't think to comment adversely on initial interest confusion at large, but simply here does so because by this time there is a specific test that applies to keyword advertising. We say that tells us nothing about, or doesn't raise any controversy in relation to initial interest confusion, much less post-sale confusion. I think that's coming close to the current position before we turn to the academic commentary. London Taxi has a bit on the point. You'll find that at tab 12 of that bundle. And this was a case about infringement in the shape of taxis, and the issue was from some angles there might be a better case for the defendant. For the defendant, in some angles for the claimant, and I wanted to pick it up really at 255 without delving too much into the detail of the case and the significance of the points. But the point is that LTC primarily relies upon the similarities between the respective front views of the trademark and the new Metro cab. It accepts that the rear views are quite different and places little reliance on the side views. LTC contends that the front views are important because that's what a consumer of taxi services sees when hailing a taxi in the street. I accept that the front view is the most important view in these circumstances. I don't accept that it's a predominant significance. Consumers of taxi services see taxis from a variety of angles depending on the circumstances. At a rank, the main view can easily be the side view. Even when hailing a taxi, the consumer will see the side view when getting into the taxi. Not infrequently, the consumer will see the rear view if the taxi has stopped beyond where they were standing, or indeed has decided to pick up somebody else, which is particularly. The fifth point is that consumers of taxi services also see taxis under a variety of conditions, including different weather conditions, times of day, and street lighting. And I agree with LTC that allowance must be made for this. This is the point that I was really trying to make earlier, that we don't specifically rely on muddiness as being an issue, but the variety of weather conditions and the variety of angles is significant. When it comes to the variety of angles, as I say, in our submission, pretty much any top view or elevated view of the Dream Pairs logo on the side of the boot, curved surface like that, will flatten it, and that is significant, we say. I have not yet taken you to the judgment of Mr. Justice Birss, as he then was, in the Thomas Pink case, and that came into the bundle quite late. I'm not quite sure where we put it. It's right to the end. It's in your 49. Thank you. And I believe this one has been sidelined as well. Yes, 44, so it's the last in the bundle. And it's page 1469. This was a case in which the well-known, I say well-known because they're right in the corner, Thomas Pink and Victoria's Secret, sort of lingerie and nightwear and that sort of thing, and an argument about whether there was, whether the word pink could be protected. And of course, the way that the word pink was used by Victoria's Secret, the defendants, was relevant. And as so often in clothing cases, there was a discussion about hang tags, swing tags, things at the point of sale, shop signage and so on, POS material as it's sometimes called by marketing people, and then what happens to these items, many of which would be given as gifts or something that would be worn later and then present, perhaps not down the street for many of the Victoria's Secrets items, but certainly when viewed by another person. Now, it says, Lord Justice Birss was dealing with the issue here in 142. I'll consider the use of the sign pink by the defendant when it's emblazoned prominently on a garment. Used in this way, the sign is meant to be seen by persons other than the wearer when the garment is worn after purchase. The defendant rightly did not suggest that this sort of use was purely decorative. It's not. The person looking at someone wearing one of these items of clothing will see the sign pink as having some origin significance. In this context, the person seeing the garment will not see a neck label or a swing tag or any other indication where the goods have been bought. And I find that in considering the effect of the use of the sign visibly on the garment, the post-sale context is a realistic and fair context in which to do so. It does not involve either of the two further elements relied upon by the defendant, neither the swing tag nor the shop. I just wanted to make a couple of submissions in relation to the words reasonable and fair. It's right, and my learned friends rely on a judgment of Mr. Alexander QC sitting as the appointed person in Christie's. It's right that if the post-sale environment that's being posited is somehow fanciful, but just about imaginable, if you think hard enough, that's to be left out of account. The court's not concerned with those sorts of things. And you don't get to slip it in by virtue of the significant proportion of consumers argument. We say that's not our case at all. We're dealing with the quite normal vantage point. Indeed, I don't need to put the case this far, but it might be said to be the main view that people have, third persons anyway, of these articles being worn by others, or by the people who bought them. And we're dealing with a perfectly normal flattening of perspective when things are viewed from that vantage point. We're dealing with relatively small logos that, had they perhaps been bigger or positioned differently on the goods, might have a different effect. So we say ours is both reasonable and fair as a context, just as it was in Thomas Pink. Now, there are some other decisions from the UK that I think learned friends rely upon, and I've touched on a couple of them. Perhaps the most important one, final one to finish with, which we rely on, is the Montreux Breguet Swatch and Samsung case, which you find in tab 22.
And the number?
Yes, it's 24. Yeah, thanks. Recent decision of this court. And
Thank you.
I have 22.
22 is what I thought, but I've got. No, I do have it, yeah, sorry. Right.
Still warm from the press.
Yes. This was a case in which there was some issues about what the sign involved. Essentially, Samsung smartwatches containing what we call watch face apps that effectively replicated digitally the face of a normal watch, well-known Swiss brands in many cases, or something similar thereto. And there was an issue about point of sale in that as well, because it was suggested, well, at the point of sale, people are on the Samsung app store and they can see what they're getting. It's an app, it's not a face. And there might be some similarity, but that's one scenario. But the judge below, Justice Falk, as she then was persuaded that the harm really was that the faces looked like a real watch. So you had an Omega, one of the most second biggest brand in the world, I think, behind Rolex, an Omega face that was mimicked in the watch, not only the name and the trademark, but the design. And the meticulous level of detail that Samsung were able to bring to the table through their technological wizardry was something to behold, and they could, in use, provided they weren't dimmed by being timed out or whatever, could be seen by consumers and taken for being an indication of origin in relation to a watch. And it was that distinction that the judge, Lord Justice Arnold, giving the leading judgment in 83 on page 1046, a bit more detail about the history of post-sale confusion or the post-sale significance of marks in 84. I'll draw your attention to.
Do you want us to read 84 and 85?
Yes, but in particular 84. And what's significant there is, so that's talking about the sort of history and logic, if you will, or importance of marks that are viewed in the post-sale world. But in this case, this particular case, of course, it was the same mark and the same use that was made at the transactional point that then goes out into the wild on the wearer's wrist and has a different significance. So the sign itself might change in the post-sale world. And we say, just coming back to the original discussion of the Section 10.1 cases and Section 10.2 cases, that's entirely to be expected, because in the post-sale context, things can be different, but ultimately you're still relying on the original use, not a fresh use. So we then come to the European cases, and I've dealt with many of these. There was, and I've dealt with the Christie's judgment of Mr. Alexander. The case I wanted to show you, Chanel, which is at tab 33 of that end. I referred to it earlier in passing, but it's worth sorry, yes, it is 5, bundle 5. And I think the passage that I want to take you to is not sidelined. So you can see what this case was about. The Huawei mobile phone technology company filed a figurative mark in class 9s, that's computerized goods, and so on, with a sign of vertically orientated interlocking U's or hoops or C's or whatever. And the Chanel company, you can see their trademark on page 2. They relied on two trademarks. You can see that on 1247, one of them in a circle and one of them not. I just wanted to remind you which goods were applied for. It wasn't just sort of computerized goods. It was mobile phones and mobile phone covers that Huawei had applied for. You can see that on page 1246. There's a very long list of goods. And about halfway down, no, but 7 or 8 lines down, you've got mobile phones. And then right down the bottom, you've got covers for smartphones, cases for smartphones, and so on. Now, the court, the general court, so this is an appeal from the EUIPO, held that there would not be, that the opposition should fail. And I think my learned friend relies upon 23 and 24. I wanted to show you 25 and 26. As a preliminary point, it should be noted, as stated in 20 of the contested decision, and as the EU IPO and the intervener submit, when assessing whether they're identical or similar, the signs must be compared in the form in which they are protected. That is to say, as they were registered or as they appear in the application for registration, the actual or potential use of registered marks in another form is irrelevant when comparing the signs. And as citation of authority, the orientation of signs, as set out in the application for registration, may have an impact on the scope of their protection, and consequently, contrary to what the applicant claimed, the applicant is the appellant in this system, in order to avoid any uncertainty or doubt, the comparison between the signs can be carried out only on the basis of the shapes and orientations in which those signs are registered or applied for. And what they're saying there is you've got to look at the Huawei mark straight up. You can't turn it on its side, and you can't make it look more similar to Chanel. If this were an infringement case, and I were acting for Chanel, I would submit that that's illegitimate. That's unfair. A mobile phone could well be sitting on a table in a different orientation, and it's perfectly legitimate to consider the post-sale environment and how it looks. And if you orientate that, the Huawei mark in that way, you've got a slightly thinner version of the mark.
But as you said earlier, this is not infringement, this is registration.
Case.
And this is a subset of the more general point that the difference between the two tests for likelihood of confusion, which are otherwise essentially identical, is that if it's infringement, you take context into account. If it's registration, you don't.
I mean, you do find some EU IPO decisions where they flirt with the idea of considering how a mark might be used. But it is a very guarded approach because obviously they don't have the examples, they don't have the evidence, they don't have really, they've got to consider notional and fair use. And it might be said that that brings in a sort of a groping at some of the, grasping at some of the possible scenarios. But in general, the position is as described by Arnold, which is that it's considered a registration for registration comparison. You identify usually one body of average consumers. Sometimes there are different classes. So there are goods that are the general public plus professionals and trade experts, people in the trade. But generally, it is sort of one body of consumers approach. So we say that taking account of that body of case law, it was perfectly legitimate for us to submit a trial that the post-sale environment needed to be given careful consideration and might result in a different analysis. The other grounds of appeal are to some extent parasitic upon that main point, but they may also be said to have a little bit of independent scope. I hope I can deal with them rather briefly, taking account of the indications in the grant of appeal. Not wanting to have major surgery performed upon me now. If it
Be
wasn't,
accused of nitpicking.
yes, I was being accused of it, even worse. Dominant and distinctive. The first one is that the judge, we say, made an error in paragraph 140 in identifying, so go to the core bundle, in paragraph 140. We have I might have read this paragraph very briefly, but on a different point. I agree with the claimant that it's possible for some presentations of the DP logo, the consumer would not notice the break in the outer figure. I'm unable to agree with the claimant, however, that the average consumer would not notice the P-like form in the middle of the DP logo. It is the distinctive and dominant element of the logo. What we say about that is that when it comes to simple, ultimately abstract shapes, such as these, it isn't of assistance to analyse them in terms of dominant or distinctive elements. First of all, they aren't really different elements. They're simply a sign or a unitary whole. They're not a composite. This is not a composite mark. And that might be said to be a rather irrelevant or perhaps second-order criticism. But we say that the significance of it was that the judge clearly used that as a way of distinguishing between the marks. Now, that's the first point we make, and that's the sort of independent criticism of the judgment. But of course, that is a fortiori in relation to the post-sale environment, where there is certainly not to be regarded as dominant and distinctive, that element. The things get even worse to some extent in paragraph 142, because there's an assessment of the dominant and distinctive aspect or element of the Umbro mark. 142, I don't think, however, that there's absolutely no similarity between the marks. They both involve rhomboid shapes with an outer and inner dominant element and both sit on one angle. But there are also multiple variances between the marks. I've reached the overall assessment, applying the average consumer, that there is a very low degree of similarity between the marks. They both have an outer and an inner dominant element. So the inner triangle, or sorry, the inner diamond of the Umbro mark, for reasons that aren't given, is also said to be dominant and different. We say that's a further importance and unwarranted importance given to this
Mr.
issue.
Mileage, I'm sorry, I don't understand what you just said about 142.
Have
another go.
He doesn't say dominant and distinctive, but he does refer to, he's there comparing the marks and the sign, so the two marks and the sign. They both involve rhomboid shapes with an outer and inner dominant element. It's just the word dominant there. I mean, it's perhaps again, a second-order criticism, but this is the classic way that marks are distinguished from each other, which is on their dominant elements. Because if they're similar in a non-dominant element, then it's very unlikely that there'll be any similarity at all.
Sorry, maybe it's me, but as I read this sentence that you're criticising, it says they both, that means both the mark and the sign,
Yes.
involve rhomboid shapes. So that means that's something they have in common.
Yes.
And that seems fair. Then it says they both involve rhomboid shapes. So this is both, with an outer and inner dominant element. Oh, I see. You're reading
It's the inner dominant
right.
element. Yes, maybe I'm overthinking
I
it.
read it as outer
it's-
and inner.
Yes.
You mean you were saying it's inner dominant? I see.
Yeah, inner dominant. It's talking about ours as well. I mean,
Well, it's difficult to read it
Yeah.
as applying to both,
Yes.
because in the case of the Umbro mark, what else have you got? There is
No, I
nothing
see.
else.
That's fine. That's helpful.
I mean,
Thank you.
to be fair to the judge, he does identify the central element as being, but he doesn't say that. But in fact, we say the whole process of analysing these marks in that way is illegitimate. Really, it was unhelpful. In the permission to appeal hearing, the judge said I didn't mean it in a technical sense. It's true he doesn't cite the case law on dominant and distinctive elements and so on.
It's a term of art. And
Yes.
it can't be accidental.
Yeah, that may be one way of putting it. So the other issue that we, I won't go through all the grounds, but there is what we call the missing Umbro point, and that is that the judge, in a sense, used the fame and repute that he had found in relation to the word Umbro, the Umbro logo, used that against us. So the process of reasoning was, you are well known, people recognise Umbro, it's not present, the word Umbro, in the dream pair's use. Instead, the word dream pairs is there, and therefore that is a point that militates against a likelihood of confusion. And you can see that from, I think it's 149. Now, yes, For these reasons, it appears to me that references to dream pairs as the brand and the absence of any reference to Umbro are relevant context for assessing the question of confusion. We say that's going too far in terms of context. The absence or presence of things, and it also collides with the principle that when I sue on a registered trademark, I am relying on the mark in the form on the register to start with, not a composite mark comprising logo plus Umbro. And to be fair to the judge, he did say that he would have reached his conclusion anyway. For that reason, I do need to challenge this and say that that was not a legitimate point, and I hope that would be, it's sufficient simply to state it in those terms. It is not the correct approach to analysing analysing distinctiveness and fame and repute, to then hold that the absence of that sign effectively is holding that the opposite of what the true legal position is, which is that normally the more you've used a mark, the greater the penumbra of protection. This is trite law, but in all those cases, it could be said, well, that generates a knowledge on the part of consumers that it means a certain undertaking. If the name of that undertaking is absent, then it must be taken into account. I should say, just as a matter of evidence, there are plenty of examples in the bundles of the sign being used without the word Umbro. Sometimes it has Umbro, sometimes it doesn't.
It's slightly curious, isn't it? The test is definitely, you would say, is to consider the context without the word Umbro.
Yeah.
But that's not because the absence of Umbro is a relevant feature.
It's not because the absence of Umbro is exactly so. It's because we have to look at the specific mark that's relied upon. But actually, when it comes to words, and there's a passage in my Lord Justice Arnold's judgment in Enterprise where he says, he's talking about the difference between a logo form mark and a word mark, and they do have a different significance when consumers. They do perform a different purpose. And so it's difficult for a party to say, well, you know, I had my brand next to your sign, because people might think, okay, so we're dealing with indirect confusion here, or we're dealing with a spin-off or a partnership or whatever, a collaboration, as someone's called. I wasn't going to take the point on the wrong comparison of the marks for fear of nitpicking. But we say the judge, the judge perhaps failed to give sufficient reasoning in relation to that, but I don't think it really takes us anywhere. We say that likewise, his inconsistency on the conceptual analysis, I've cited the paragraphs in our appeal skeleton. It's quite clear he's talking about the average consumer's perception of the marks as seeing this as a P-like form, and again, for the same reasons that you don't analyse dominant and distinctiveness in relation to such marks, it's meaningless to talk about a concept unless they clearly convey a concept, and that is what it was. But again, it's more of a criticism of the way the judgment is written, or the text of the judgment, rather than something that has a great significance in our appeal. Just a moment. Yes, I'm reminded that the judgment does deal with post-sale confusion in a few different places, and just really for your note, for completeness, that paragraph 94 states the position. So that's of the judgment, so it's tab 5 of the core bundle, page 78. The complaints at trial focus primarily on the presentation of the DP logo when advertised for sale on the website, but that was not the only allegation of infringement, and the claimant relied upon all possible uses, including advertising, offering for sale and selling the goods, and on post-sale confusion. And then he returns to post-sale uses later.
I don't think you've taken us to paragraph 160 either. And I presumed that had you done so, you'd have said that the judge had been in error in the final sentence of that paragraph.
I will just remind myself of that. Yes. I've reached the same conclusion in relation to the allegation of post-sale confusion. The claimant accepted that the degree of attention would be the same. Yes. I've explained the differences between the sign and the marks, and I consider these to be apparent to someone with the characteristics of the average consumer who saw the relevant goods. I don't think that's a material difference. I'm very grateful, lady. That was really where I started, which is that the judge was dealing with his own assessment and a consumer whose visual appreciation was conditioned by an understanding that this was a square, and therefore, using my brain, I can see that it's a square at an angle when I see it at different angles. And that was his analysis of post-sale. We say he never considered the scenario that we've posited, which is, we suggest perfectly normal, conventional, realistic, and fair when it comes to these goods. But those are my submissions.
Thank you very much indeed. Yes.
Lady, my lords. This court will appreciate that what has been challenged here is a multifactorial assessment that there was no likelihood of confusion in respect to the use of the DP logo, the DP sign, on a variety of items of footwear, notwithstanding the judge found that the double diamond registered trademarks had a reputation and were distinctive in relation to specific classes of footwear, both in the context of Amazon use and in post-sale use. And this is a circumstance where the judge considered both sets of environments and considered, applied the right legal tests. He analysed the evidence before him and then applied the correctly stated law to that evidence. There is no error of principle, and he was not wrong. In reality, what this appeal is a second attempt to come to this court to seek to make a different finding as to the likelihood of similarity in relation to the DP logo and the double diamond sign. And by doing that, they seek to suggest that the visual impression of the double diamond registered trademark should be more square than diamond, and secondly, that the visual impression of the DP logo, when viewed from particular angles or a particular perspective, would be perceived as being more diamond-shaped. And the problem for Iconix on this appeal is that that is what they invited the judge to do, and the judge indeed addressed those in both sets of environments by reference to the evidence before him and by reference to the way in which the case was put by Iconix to him, and considered all the relevant items of footwear, all the relevant contexts, and considered both in the Amazon context and the post-sale context that there was no likelihood of confusion. This isn't a case of interest about post-sale confusion law. It was accepted that you could have post-sale confusion law. The judge addressed the facts in relation to that in the way in which Iconix presented its case and came to a conclusion which it was entitled to come to. Now, it is very important, my lady and my lords, when approaching this appeal, that we do actually focus on the way in which the case was put before the court and what the court actually had in terms of evidence, especially when we come to post-sale confusion. But rather traditionally, I am going to approach this appeal, if I may, by reference to the grounds of appeal and address each one insofar as my learned friend is still contending them, so that the court has clearly in mind what the arguments were, how the judge addressed it, and why there's no error of principle in relation to each of the grounds of appeal. So on that basis, I'm certainly not going to read out my skeleton, but I am going to focus on parts of the skeleton that are particular of importance, and also insofar as my learned friend has highlighted further points this morning. But everything we've said on the skeleton, I stand by for the purpose of this appeal. The first ground of appeal is the alleged failure by the court to make a separate comparison of the marks and sign.
Do you want us to turn up your...
Yes, well, we're addressing our skeleton, my lady, at paragraphs 39 to 46.
Yes, well, you set out at 39 very clearly how it was put at first, and it's not really been picked up.
It's been put very lightly indeed, my lady, but there is one part which I didn't take you to in our closing, in our written submissions, which I need to put to you, should show you, because this is a point which should never have been raised by the appellants. So we do rely on the way in which it was presented in its pleaded case, in the oral case, and in the written closing submissions. I've given you the oral closing submissions in the skeleton, and I've given you some references in relation to the written closings. No distinction was ever drawn. But in the pleading, it went much further. And can I just show you that, my lady and my lords? So the pleading starts in the core bundle, particulars of claim, at tab 7. Pages 106, 107 set out the two registered marks upon which Iconix relied. Paragraph 10 set out the basis of the reputation in relation to those marks. And you'll see the starting point at 10.1 is they relied on a specific diamond logo to justify all of the reputation for both of the marks. In 10.1, 10.2, 10.3, 10.4, 10.5, 10.7, 10.8, they make the same assertion each time, a logo identical or material identical to the marks. So in relation, there's no distinction drawn. I'm not going to labour it too much more, but of course, if you then go to our defence, where we actually pointed out that the logos are slightly different, and that we point out in our defence behind the next tab, at paragraph 8.1, page 149, we point out the differences. Mm-hmm. This is the important point. Behind tab 9, this is their reply. This is what they say the court should be doing. Paragraph 2, picking up the third sentence, the width of Mark 2 is 3.5 times that of its height. The width of Mark 1 is twice that of its height. Further, Mark 1 and Mark 2 do not differ in their distinctive characteristics or in their overall impression that they create on the average consumer of the goods for which they are registered. There's a positive allegation that there's no difference between the two of them. And that was the basis upon which the case was put below, and upon the basis upon which the judge addressed the case. Despite the fact the judge himself identified in his judgment that the marks weren't identical, he was reasonably entitled to come to the conclusion that he did, that the marks created the same overall impression.
Well, and as you rightly note, whilst it's not been abandoned as a ground of appeal.
It has not been pushed very hard, no. But it is their first ground of appeal, my lady, and it was a bad one that should never have been taken. The second ground of appeal, ground 1.2, contains 4 sub-elements. It's all about the alleged inconsistency with which the judge addressed the similarity of the marks and signs. The first element, which we address in our skeleton of paragraphs 48 through to 51, is that the judge took an inconsistent approach to the conceptual aspects of the DP logo. Now, my learned friend very recently has just suggested he still rely on this, albeit lightly again, as I understand it. Now, what he's asserting is that the judge either subconsciously or unknowingly, pursuant to the alleged principle of conceptual counteraction, applied that doctrine or that principle to the alleged visual similarities between the DP logo and the Double Diamonds loader, so as to come to a conclusion that they would be lessened, similarities would be lessened. Now, there's absolutely no basis for that submission. The principle wasn't mentioned to the judge, nor was any authority cited to the judge supporting such a principle, and he wasn't invited by either party to adopt such a principle. On the basis, on the contrary, what the judge did, he found as a matter of fact that the DP logo had no conceptual or oral characteristics at all. You can see that from the judgment at paragraph 35 of the judgment, my lady and my lords. So paragraph 135, I hope I didn't misspeak, 135. On a visual assessment alone, the judge found that the DP logo sign was only very faintly similar to the marks. That's the judgment he explains himself at 140 through to 142. The way that it's put in writing by my learned friend is that when you read the judge's judgment at 134, because he uses the indefinite article to refer to a P as being the inner shape when he's describing the DP logo, that is suggesting that the judge considered it to have a conceptual meaning. Now, that wasn't pursued by my learned friend orally, rightly so, because it's a bad point. When one reads 134, all the judge is doing in that paragraph is describing the shape of the DP logo in words which are fair and reasonable to describe visually, to describe in writing what he's saying visually. But in any event, if you go to paragraph 135, when he's explaining that there's no oral or conceptual element to the mark or sign, he says they're just shapes. While the average consumer might think the P shape had some point, I do not think he or she would necessarily attribute a sound to it. So even though he's identifying the P shape, he's not attributing any sound to it, and therefore the judge is saying that the average consumer could not have perceived that as being something which was a P and therefore had a conceptual meaning. So both in the context of paragraph 134 and the subsequent paragraph 135, it is, in our respectful submission, a unfair and wrong attribution to suggest that the judge attributed any conceptual concept to the DP logo when he was merely doing a description of what it looked like visually. Now, for this court to note, I'm sure two members of the court already know, but for this court to note, the principle of conceptual counteraction is explained by the Court of Justice in the Equivalenza case. I wasn't going to go to it for this point, but I'm going to go for the next point that I need to address in my learned friend's attack. That's in the authorities bundle, fifth bundle, tab 30, page 1208. And just briefly, just to set the context, at 1209, you can see that the mark which was applied for a black label by equivalenza set under paragraph 5, and the mark which is being used to oppose it is paragraph 9, the label mark. And for the purpose of this, I can go straight to paragraph 74 and 75. And this is at page 1217. So what the General Court is doing there is emphasizing at the stage of assessment the similarity of the signs as a whole, their conceptual dissimilarity must be borne in mind. That in accordance with the case law of the court, the global assessment of likelihood of confusion implies that the conceptual difference between two signs may counteract phonetic and visual similarities between them, provided at least one of those signs has, from the point of view of the relevant public, a clear and specific meaning, so that the public is capable of grasping it immediately. In that regard, the court has held, paragraph 44, that the assessment of the conditions of such a counteraction forms part of the assessment of similarity of signs at issue, which follows the assessment of visual, phonetic, and conceptual similarities between them. However, it should be noted that the consideration is intrinsically linked to an exceptional case in which at least one of the signs at issue has, from the perspective of the relevant public, a clear and specific meaning which can be grasped immediately by the public. It follows that only if these conditions are satisfied in accordance with the case law cited in 3 paragraphs of present judgment, the General Court may dispense with the global assessment of likelihood of confusion on the ground by reason of the marked conceptual differences between the signs at issue and the clear and specific meaning which can be grasped immediately by the relevant public of at least one of those signs. Those signs produce a different overall impression, despite the existence between them of certain elements of similarity visually or phonetically. So it's a very limited principle of doctrine, which applies in very rare circumstances where the court finds that there's a particular conceptual meaning attributed to one of the signs, which effectively overrides any particular visual similarity, such that the conceptual meaning is such to dispel any chance of similarity between the mark and the sign. That is clearly not what the judge did. He wasn't invited to do it, he didn't consider that, and he didn't in any way apply that principle when he was considering the mark and the sign. It is, with respect to my own friend, a point that it is completely bogus. What the judge did do was to look at the visual similarities between the marks alone, and on viewing the two marks and the sign in the relevant context, he found that there was no relevant conceptual or component, but there was some degree of similarity, which he summarizes in 142, based on the visual similarities, and he was entitled to come to that conclusion. He is no way tainted, as my learned seeks to suggest, by doing something which was to take into account some conceptual aspect of the DP logo, to make the differences different. More extensive. Now, the next part of his bound at 1.2 is the one which is trying to feed in specifically into the post-sale confusion point. And it's very important to understand what actually is being criticised here. So, this is our skeleton paragraphs 29 through to 41.
Paragraphs?
Paragraphs 29 through to 41. And what is being said is the judge took an inconsistent treatment of the conception of the signs as it was used. The first complaint, actually, in his Malone skeleton, is that the judge conducted a paper exercise when comparing the DP logo and the double diamond registered trademarks, assuming the judge was assessing the appearance of the DP logo in one idealized presentation, square on and crisply printed, and failed to give any weight to the fact that the average consumer would see the DP logo from different angles and in different pictures, both on Amazon and post-sale. That, again, is wrong, is not what the judge did. We make 4 points in relation to this.
So I can more
Ask 52 to 54. It's theirs.
Oh, I do apologise. I misspoke. I apologise. So our skeleton paragraphs 52 to 54.
It's their skeleton.
Their skeleton. I do apologise. Their
That's
skeleton
all right,
29
I
to
found my way.
41. I do apologise. Sorry. Now, 4 points. Firstly, if the judge had only done this so-called paper exercise, he would not have erred, because that was how Iconix had pleaded their primary case. Their primary case was that the double diamond registered trademarks and the DP logo were similar when viewed square on, such as to give rise to likelihood of confusion. The case wasn't limited to a particular form of presentation of the DP logo or in a particular depiction on or by the Amazon website. And indeed, it was the particular use of the registered mark square on, which was the justification for the joint tortfeasance claim against the second defendant, and the justification for a declaration of non-infringement, and indeed the width of the injunction which the claimants were seeking. To make that good again, my lady and my lords, may I ask you again to turn back to the core bundle. Tab 7. And the acts of which complaint are made are start at paragraph 12 and at page 111. And what they complain about is the sign square on in the form as set out at paragraph 12. And then in paragraph 13, they say that sign has been used in respect to footwear, alternatively in respect to footwear suitable for use in sport or as active wear. In 14, they give particulars of use, specifically in relation to the Amazon pages. But then the claim isn't limited to the Amazon pages, isn't limited to any specific angle. The injunction which they seek, which is set out at page 117, is use of the sign as defined. That's fair belief 1A and 117. The joint liability case against the second defendant is by reference to the fact that the second defendant is the registered proprietor of its trademarks using the sign. And you can see that in paragraphs 29 and 30 of the particulars of claim. And it's because they're authorising the use of that sign that joint tortfeasance is claimed. And this court will also be aware that the claimants were also seeking a declaration that those registered trademarks were declared invalid because their use was said to be confusingly similar to the marks which others had wrong. So the judge was required in his judgment to consider the case of the square-on case in order to consider the primary case put by the claimants. Secondly, as a matter of law, we say that the first stage for a judge in any of these cases is to identify the sign which is alleged to be infringing and make a mark for sign comparison to assess whether the mark and sign are similar. And at that stage, they shouldn't take into account marketing circumstances, which is the matter which you need to consider when you are considering the likelihood of confusion test when you're doing the global association. And we say that is what the Court of Justice has told us we should be doing, and you'll see that from the equivalenza case. So if you go back to the authorities at bundle 5 and go back to tab 30, and this time, if I could ask you to pick it up at paragraph probably best pick up paragraph 68 to get the context. The court has held that in order to assess the degree of similarity between the signs at issue, it's necessary to determine the degree of visual, phonetic, and conceptual similarity between them, and where appropriate, to assess the importance to attach to those various factors, taking into account the category of goods and services in question and the circumstances in which they're marketed. That's Lloyd, amongst others. At 69, admittedly, as the Advocate General has in essence stated in points 53 to 55 of his opinion, that case law has given rise to divergent applications by the EU courts. In that it's been possible to take account of the marketing circumstances at that stage, as the case may be, of the assessment of similarity of the signs at issue, or the global assessment of the likelihood of association. 70. However, it should be made clear that although the marketing circumstances are a relevant factor in the application of Article 8(1)(b),
Excuse me.
they are to be taken into account at the stage of the global assessment of the likelihood of confusion, and not at that of the assessment of the similarity of the signs at issue. As the Advocate General observed, in his opinion, the assessment of similarity of the signs at issue, which is only one of the stages in the examination of the likelihood of confusion with the meaning of Article 8(1)(b), involves comparing the signs at issue in order to determine whether those signs are visually, phonetically, and conceptually similar. Although that comparison must be based on the overall impression made by those signs on the relevant public, account must nevertheless be taken of the intrinsic qualities of the signs at issue. However, as the EU IPO rightly argues, taking into account the circumstances in which the goods or services covered by the two signs at issue are marketed for the purpose of comparing these signs could lead to an absurd result that the same signs could be classified as similar or different depending on the goods and services they cover and the circumstances in which they are marketed. It follows from foregoing that the General Court urged in taking account of paragraphs 48 to 53 and 55 of the judgment appeal of the circumstances in which the goods in question were marketed at the stage of assessment of similarity of signs at issue as a whole, and begin precedence by reason of those circumstances to the visual differences between those signs and then phonetics and similarity. Now, I am not taking the point, which my learned friend seems to suggest, that actually there's a fund that when you come to consider infringement, you look at the sign and assume it's in the paper form. That's not correct. When you come to infringement, you look at the sign as it's presented. But you do have, the court has to identify what is the sign that's being presented. If it sees it at a various angle or very perspective, or from top or from side, the court still got to ask itself the question, what is the sign I'm looking at? And that is what the judge did, and I'll show you in a moment. But what you shouldn't do at that stage is somehow take into account marketing considerations, post-sale use and so forth, because that is suggesting something which needs to take into account when you're looking at the global assessment at a later stage, again, which is what the judge did. So you must ask yourself, what is the sign, the court must ask, so what is the sign that's being applied to the goods when it sees the alleged infringing use? And that's what the judge was invited to do, and I'll show you what he then did.
Sorry, Mr. Van Heegen, I'm not,
Yes.
just want to make sure I'm not getting in a muddle. When this part of the judgment is talking about the stages in the analysis, and they don't use those words,
Yeah.
but that's what they're talking about.
Yeah.
They talk about classifying as similar and different
Yes.
set of results. Am I right? What I think they're talking about is that in the law, one of the elements of the test is whether the mark and the sign are similar.
Yes.
Because if the mark and the sign are not similar, then at least under 10.2, that's the end of the story. And
Absolutely.
you never consider confusing
Just-
them. You never consider confusion because they're just not similar. So at that point, you're making that comparison, and that's what they're talking about here, isn't it?
But not only that's the degree of similarity has to be taken into account here as well.
Yes, with the degree of similarity in order to reach a binary conclusion that either you're similar or you're not. And
No,
if you're not
no, with great respect, my lord, no. The binary conclusion, if you're not similar, you don't go on to the likelihood of association, likelihood of confusion, global assessment tool is one aspect.
Right.
But you then also have to make, traditionally, one also has to give some value as to how similar they are, because you then feed that in when you consider the global association.
No, I understand, yes,
So it's not simply a binary threshold. They do that, obviously, if it falls below it, you don't go on. But at this stage, the court needs also to take a preliminary view in terms of the degree of similarity between the
Yes.
registered mark and the sign. And I accept it's a sign as used in an infringement context, but that is at that stage you look at the alleged infringement and you say what is the sign that's being used, and then you make the comparison.
Right, but take facts which are not meant to be this case. I'm trying to not do it on the facts of the
Yeah.
case. Let's say that you look at the marks side by side in this element of the test to work out whether you satisfy the basic threshold of similarity or not. And if you don't get, if it's not similar at all, that's the end of the analysis.
Absolutely.
If it is similar, then the degree of similarity matters. I get that. And that's the point you made. And the way I put it earlier was wrong because of that. I get that. So you at that stage, you're comparing the mark and the sign essentially as they're presented on the register, or in the case of a sign, as it's pleaded and there it is. You look at them.
Absolutely.
But are you saying that this means that once you've done that task, when you then come to consider confusion, you could ignore the fact that in actual use, the sign in question is used in such a way that makes it look more similar to the goods, to the mark, than it would have done if you're looking at it side by side? You say you ignore that.
No, I'm not, because you've got to, the difficulty that my learned friend is merging, you've got to look at what is the alleged infringing use. In relation to alleged infringing, what is the sign that's being used in relation to that alleged infringing use?
Yeah.
And there you effectively do a snapshot stop and ask yourself, what's the sign that's being used in that alleged infringing use? And obviously the paradigm case is point of sale. What's the sign that's being used there?
Yeah.
And you ask yourself, how similar is it to the registered mark at that point? And then you go and ask yourself the global, if I'm going to get over the threshold, you ask yourself the
Yes.
global. But what you don't do at that point is say, I assume that could also be, that sign in that particular usage could also be presented in a room with very poor lighting, or at another angle, or at where there's a blizzard so I can't see the mark per se. You've got to have some foundation for making a comparison with what the sign is that you are looking at, as opposed to the registered mark. And that's what I'm saying at this stage, is what the court is required to do. What I'm saying is that is going to be put, as I understand it, in writing, certainly by my own friend, and what he's trying to merge into post-sale confusion case, is that the judge did something wrong. He sort of brought with him, when he came to consider post-sale confusion, and a comparison which was effectively a paper comparison. He didn't. He brought with him a comparison of the sign which he understood the other side were relying on as being the infringing usage sign, and made the comparison in relation to that, which I'm going to show you in a moment. And therefore, that was a legitimate thing for him to do, and that's what he did do in terms of his description. What you mustn't clutter with that at the stage of the mark and sign comparison is some sort of, well, in certain marketing uses, the sign could be obscured with mud, for example, or couldn't be seen, because that's totally illegitimate when you consider the mark sign comparison, because you are still got to found your case on what is the sign that's actually being applied by the alleged infringer in the first place.
I don't understand the relevance of these submissions at all. This is not a case in which there's ever been any dispute as to what sign complained of was. By contrast, both my lord and I have had experience of cases where one of the disputes at trial is precisely what is the sign being complained of, because the parties are at odds on that question. But here, there's never been any dispute. It's the device in question. The dispute is, firstly, as to the level of similarity. Secondly, as to the impact of the perception of the consumer in the post-sale context. And on the perception of the consumer in the post-sale context, surely this authority is against you, because it says in terms that the marketing circumstances are a relevant factor to be taken into account at the stage of the global assessment of the likelihood of confusion.
Not against me at all, my lord, because we embrace that. We accept that's what the judge was asked to do, and it's what the judge did do. We're not saying that there's nothing between us in terms of the law on post-sale confusion in relation to this issue at all. He should take into account post-sale, the context and the use, but he shouldn't be criticised when he's doing the side-by-side comparison in terms of the mark and the sign complained of, that is going through a slightly more mechanical process of identifying what is the sign that you are complaining about. Is it sufficiently similar, or how similar is it to the registered mark? Which is what my learned friends' woven submissions come to. Because they are suggesting that the judge was inconsistent in terms of treating the sign, the DP sign that was actually used and about which they complain. So what the judge did was what he was then asked to do, which was to make a comparison, both in the classic side-by-side form, insofar as they're relying on the DP logo for the purpose of the registration. Secondly, insofar as they're relying on the Amazon context. And thirdly, insofar as they're relying in a post-sale context as to whether the sign would be different from the sign which is already considered in the Amazon context. Can I just make that good as to what actually they were specifically asking the court to do? Because the court judge asked, well, what am I meant to be looking at? What are you asking me to look at in terms of the images that you are claiming to be infringements? And you'll see that in paragraph 53A of our submissions. And may I ask you to take the supplemental bundle and turn to the way in which the case was put before the judge. You'll see this from the closing all submissions of my learned friends, and this is in supplemental bundle tab 6. Picking it up at page 239 of the bundle. And can I ask, my lords, to read the submissions by my learned friends at starting at manuscript page 174, line 12, down to 180, line 21.
Sorry, you want us to read
174, line 12.
all the way through to page 180?
180, line 21. I'm grateful. So the 2 points I want to make is, one is the submission which the claimants made at 176 line 20 to 2020, line 20 to 23, is that no matter what you look at, the claimant says in whichever presentation you have of this sign, there's similarity. So that they were putting their case as high as I'm suggesting, that if you look at square one thing.
Yes, but one has to read this as a whole. And at
Yeah, yeah.
179, the judge puts the point that there's a continuum, and that's agreed to.
Absolutely.
Moreover, Mr. St. Quentin goes on to say that one shouldn't just look at the printed black and white version.
Yes.
That's not actually how the sign used. And he goes on to say that all the uses need to be assessed differently.
That's right. And so what they then agree is that the appendix which is put forward by the defendants acts as being representative of the different ways in which the DP logo appears on the various footwear. Now, that appendix you'll see in the sorry, he agrees that when he comes back at short break at page 187 of the manuscript, page 242 of the bundle. And that appendix you'll see in the same supplemental bundle, tab 4, starting at page 186 through to 194. So these are the images which were being agreed as being representative of the different ways in which the DP logo appears on the various types of footwear. Now, could I then ask you to look at what the judge then does as a judgment, which...
Those are all Amazon pictures.
Those are all Amazon pictures, that's correct, yeah. But, lady, you must remember, and I'm jumping ahead, that this case was suggested to be a case of infringement based on Amazon. And what I'm going to show you is the post-sale was a one-line give at the end of the case, where they said, of course, then when you come to consider post-sale, what you can't take into account are two aspects. One is the DP brand, and the fact that Umbro doesn't appear in relation to the context. I'll make that good in a moment, which is why all the submissions you've heard this morning about the law about post-sale confusion are effectively immaterial, because the judge had that clearly in mind when he came to consider the nature of the uses he had to look at in a post-sale environment, just as much as he had to look at in the Amazon environment. So, my lord, yes, if you, and my lord, if you can go back to the judgment. Pick it up at 95, 96. The judge therefore addressed the presentation of the goods and the DP logo on the Amazon pages at paragraphs 95 and 96, and then again at 134 through to 140, having regard, as he makes clear in judgment at 138, to the images most relied on by Iconix. This is Iconix's best case. And he carefully considered the effects of the angles and perspectives, and in relation to these, he, having regard to the best case, he still found that there was only a vague similarity. Now, the best case images come from Iconix's own pleaded case. They're the, you'll see in the judgment at page 92, the judge has set out the images from, a number of the images from Iconix's pleaded case, and these are addressing Iconix's best case, because these are mirroring the images which Iconix relied on in their closing written submissions, and you can see that in the supplemental bundle behind tab 3, picking it up at 75. Paragraph 8. Defendants use a sign in the UK commenced in 2018 in almost exclusively in connection to the investment offer sales of footwear through online retail Amazon. Some examples appear below. And you'll see on page 76 that what they have set out there is exactly the same images which I've just shown you in relation to the judgment, but it doesn't include the image which comes from the defence, which you see in the bottom right-hand corner. And just to make this good, when you go to paragraph 70 of their closing submissions, page 111, as noted, a core complaint in this case is about advertising of sale of the footwear on Amazon. In respect to that use, it's the presentation of signs on Amazon that is relevant. Some examples of the use of signs are shown on page 2 of the skeleton, and then he gives some further examples, which in our submission are not materially different over the page at page 112. So what the judge was doing in the judgment was looking at Iconix's best case.
Take these quotations in context. So I just happened to see, because my eye fell upon it, at page 113, 71.5. For consumers who see the products after they have been purchased and are in use, the sign is practically indistinguishable from the marks, and then they go on and give examples, such as the photograph at the top of page 114. So the proposition that they were confining their case to the Amazon use, if that's what you're arguing, is incorrect.
I'm not saying that, my lord. What I'm saying is the way in which they put their case, and I'll show you. I'm going to make it good.
Well, let me finish what I was saying. Because if you look at the foot of 113, and again, this is just what my eye has fallen upon by chance, they say that gives a realistic perspective of a consumer seeing that shoe post-sale, looking down at the vertically presented site. So they were clearly presenting to the judge the need to consider the perspective of the consumer, not looking at eye level, but looking down at the foot.
Yes, what I'm going to show you, my lord, is when the judge came to consider it, he considers the sign in its traditional form as registered. He looks at the sign in the Amazon context, and then he considers a sign in the post-sale context. And what I'm putting to you, however, is that he was doing his best to address the case that was being put to him by Iconix, which was that those images which is attached to the end of his judgment were said to be the best examples that they were relying on.
That's not what this says, as far as I can see. They certainly relied upon the Amazon use, to be sure, as you demonstrated, but they also rely very clearly upon the different impact of the sign post-sale.
Yes, and the judge addresses that, as I'm going to show you, and finds that it's still only vaguely or faintly, very faintly similar in the post-sale environment as well, and he was entitled to come to that conclusion. It's not an error that they don't like the conclusion he came to. But what I'm saying is it's unfair on the judge to suggest that somehow he's looked at it in a way which is excluding their best case. It's not. He addressed their best possible case, both from the perspective of the Amazon use and generally when he came to consider post-sale confusion.
Can I just,
Yes.
I don't want to get in a muddle. I just want to understand in a simplistic, forgive me, way what your submission is.
Yes.
Because what I thought it was, and now I'm not so sure, which is why I
apologise, my fault.
not at all, was that because of the way the case had been put by your opponents, the only visual images that the judge had to consider and were the visual images we've been shown, but also the only perspective foreshortening or whatever that the judge had to consider was in those images, and that was the limit of their case. And that was what I thought you were essentially trying to say, but that doesn't feel that is what you're trying to say now, and so I don't really understand what the point you're trying to make is at all.
I'm trying to say that the judge was asking what am I meant to be looking at in order to look at the similarity of the sign and the logo. so that I understand how close you say it's meant to be. And there are myriad of images in the disclosure here. I know your primary case is Amazon, but what is it, the ones you want me to look at? And so what the judge has then given, agreed by the parties, is the appendix, which identifies all the various natures of the use of the logo on various issues. And then he relies on what he understands Iconic's best case to be in terms of the angles and presentation and so forth, which is suggesting the similarity of the sign and the mark. And those come from the Amazon pages. These all come from the Amazon pages.
Sorry, Mr. Chairman.
Yes, of course.
What I think you're now saying to me is that he wasn't supposed to be considering a slanted version of an image in those Amazon pictures. He wasn't supposed to be doing that. Is that the point you're making?
No, I'm saying he was supposed, he's allowed to look at that because that's the sign that's being used. And he has to ask himself, what is that sign?
So he's allowed to look at the Amazon picture.
Yes.
And then he's also allowed to think about what the thing in the Amazon picture would look like when it was worn on a shoe and being looked at from height.
Yes.
Yes or no?
Well,
Because I thought the whole point of your submission for the last 10 minutes has been that the answer to that question was no, and now I'm not so sure, so I'm confused.
it's no insofar as that is the sign that he, it's common, and the sign that he was asked to be looked at was the DP logo sign.
Mm-hmm.
He looked at that in a square-on aspect. He looked on it in all the rotations and angles and perspectives that the other side relied on. As
He's
being
allowed to think of his own rotational angle perspective, which wasn't in those pictures. As long as he's looking at the thing in the picture and imagining what a rotation that isn't in the picture, but his own rotation in his mind, is he allowed to do that or not on your case?
At the point of sale in relation to infringement, the Amazon sale, no, because it's a classic infringement case where you've got to look at that. In terms of post-sale confusion, then he can hypothesize, as he does, that it could be in any particular realistic environment.
Because
Yes.
what I thought you were saying, what we were looking at, was you were saying at point of sale, the judge said, these are your best pictures.
Yes.
This is what I'm finding.
Yes. And
And that's that. And he can't be criticised, you say, for that.
so
You then say he did properly go on to consider post sale, and that's where the appellant, that's the complaint now of the compellant largely,
yeah.
and you're saying, well, he did that fine as well.
yes.
And
perhaps
what we
that-
now know
sorry.
from looking at the skeleton argument is how that was, the post sale aspect was put.
Well, let me cut straight through it then, the way in which the post-sale was put, because I'm going to come
Go
back.
for it.
Post-sale was put in closing. You've got those closing written submissions in front of you. Paragraph 83.10. So that is, let me get that, tab 3, page 130. This is what they said in writing in terms of post-sale.
Well, except that you've carefully avoided the paragraph that my eye happened to fall upon, which is 71.5.
No, I haven't carefully avoided that, my lord, because these are all them asking about the issues about whether or not the mark is highly similar to the mark, in fact indistinguishable, so forth. But what they say in terms of their submission,
I think you accepted when I asked you earlier, and if you're resigning from it, please tell me, that 71.5 was talking about post-sale confusion.
well, it is an image which came out of the disclosure upon which they relied, which is an example of post-sale use in the sense that it's an image showing the boot having fallen apart. Yes, but
The submission is that for consumers who see the products after they've been purchased and are in use, the sign is practically indistinguishable. And then in support of that, making good that submission.
they rely on the
Rely
money
on
boot.
the photograph.
Well, not just, the money boot is the second one. The first one is the perspective.
Yes.
Yes, Yes, well, which I'm going to come to in because I think the judge addresses that. But I want to show how focused it was by the time we actually came to closing.
But these are the closing submissions, and
They
they're
are.
plainly relying upon post-sale use.
Yes,
Yes.
they are. They are. But the way in which it was put, as I said, the
Right.
core is 83.10. And in relation to that, they have rightly reserved from the first sentence. They don't accept, they accept now that the submission that the consumers will have an even lower level of attention to detailed and purchase of keys goods is wrong. They accept that actually it should be the same level of attention as at point of sale. They then say they also be presented and signed with different contexts, consumers are even more likely to be confused. So that feeds into what my Lord Justice Arnold was putting to me. And then orally, it's put this way. So if you can go then to tab 6. I'll pick it up at page . Let's be absolutely fair. At page 232, line 22, the claimant puts its case in a number of ways.
So internal page?
Sorry, internal page, I do apologize, 148, bottom of the page of 232, line 22. The claimant puts its case in a number of ways, but in my submission, it's just a sensible way for any claimant to proceed. However strong one thinks the case might be, there must be a recognition that there are no guarantees of success on every basis. But that's not to say that the claimant has been forced to adopt some fallback position, as my learned friend seeks to characterise the claimant's case in his written closing. The primary case I put is there's a likelihood of confusion and the reliance is placed on the use of the sign in the Amazon adverts. To the extent there is reference to and some relevance of post-sale experience of the use of the sign, that has quite a limited ambit. It's really in response to the points about context that my learned friend makes, i.e. the proposition that there are surrounding aspects of the Amazon listing that might prevent a likelihood of confusion arising, which I say actually in large part are not permissible considerations in any event. So it's quite a narrow focus, not even really a focus. It's quite a narrow by the way proposition said about the confusion post-sale. Now the two, I'm going to make it good when I get there, but the 2 points about the context which they were complaining about and are still complaining about in their written submission are firstly that in the Amazon adverts, there's a reference to dream brands, dream pairs as being the brand. And in the Amazon context, the judge thought that the fact that the double diamond is being used would be a reference to the Umbro entity, and therefore the absence of the Umbro appearing in the Amazon context would be something which would give rise to a greater likelihood of confusion rather than a lesser likelihood of confusion. The Amazon context was not suggested to be unrepresented in terms of the angles post-sale, the perspective post-sale. There was no suggestion orally or in writing that there was a particular post-sale usage which wasn't considered in the Amazon images. And when I'll show you, there's a very good reason for that, because all the images of the use, there was no evidence in this case of use of the DP logo in post-sale in the UK at all. The only materials of usage in the UK were usage of the DP logo on the Amazon web pages. And that's where all these images, sorry, I do apologise, that's where these images have come from.
I was anxious
I do
to let you
apologise,
finish.
yes.
No, I was anxious to let you finish.
I'm very familiar.
So shall we say 2:05? Thank you.
Court rise if able.